Good afternoon or morning, depending on where you are with us today. Welcome to our webinar called Tech Fueling Privacy Litigation, How to Reduce Your Risk. I'm Joe Swanson with the law firm of Carlton Fields, and we're very pleased to have all of you with us today for the next hour and talking through these very timely subjects. So I will address a couple of housekeeping items at the outset, and then we'll turn it over to my colleagues to get into the substance. First off, this webinar is being recorded for educational and training purposes. This recording may include questions and poll responses provided to you during the live event. This recording will be made available after the conclusion of the live event and is posted or will be posted on the Carlton Fields website. By way of introduction, again, I'm Joe Swanson. I'm a shareholder with Carlton Fields. I'm in our Tampa office, and I'm the chair of the firm's Cybersecurity and Privacy Practice Group. So in addition to helping clients investigate and respond to data breaches and similar incidents, I also advise them on compliance with myriad privacy regulations and defend clients in litigation associated with data breaches and increasingly with privacy claims, which is what we'll be talking about today. I'm very pleased to be joined today by my partners, Trish Guerrero and Aaron Weiss, and I'll ask each of them to introduce themselves briefly, starting with Trish.
Hi, everyone. Again, I am Trish. I am in the Miami office. I am one of the co-chairs of South Florida's International Association of Privacy Professionals, hold a number of certifications with them, including their capstone certification of fellow in information privacy, and spend a great deal of my practice focusing on sort of advising companies on privacy, both before and then after if things go terribly wrong. Thankfully, we can avoid a lot of that with a few steps in advance, which we'll talk about today.
Thank you, and I'm Aaron Weiss. Joe and Trish were very gracious in asking me to join this presentation. Now, they're the real experts in privacy and things. People who operate websites, companies, and other entities who operate websites can do to mitigate risk. I'm a litigator, so what I do is after there's an issue and after it can't be resolved, that's when I get involved, and I do a lot of litigation that relates to privacy. But as I always tell people, I'd hope that the folks that you would want to see are Trish and Joe, because if you get to the stage where somebody like me has to get involved, that probably means something went wrong. So we're going to hopefully give you some tools to help to avoid to get to that stage.
Thanks, Aaron. And in that vein, I'd like to just preview the agenda for folks today. We're going to first start by talking about session replay technologies. What are those technologies? What is it that we're talking about when we use that phrase? And then we'll talk about the claims that have been asserted and the how those claims have fared as it pertains to session replay technology. Then we're going to pivot and talk about digital advertising tools. What are those and how are they being used? And then, what are the claims? What are the regulatory proceedings that have been popping up with regard to those digital advertising tools? And then finally, and to Aaron's point, an ounce of prevention. What risk mitigation tools can be undertaken to try to avoid these claims in the first instance? And even if those are not successful, what are defenses and other strategies to be deployed in a litigation or some type of adversarial proceeding that may lead to a better outcome. So that's the plan from an agenda standpoint. We'd love this presentation to be conversational as much as it can be through a webinar. And so to that end, please do feel free to send us questions along the way using the Q&A feature in Zoom. We did get 3 questions ahead of time, and we will work those into today's discussion. So rest assured that we have those and we will be getting to them in due course. And so I'd like to pivot now to the substantive discussion and start with Trish by asking her to walk us through what are session replay and similar technologies?
Yeah, so taking a step back at what goes on when you visit a website, right? So when you're visiting a website, there's a lot going on behind the scenes, and it's all based in coding. So for anyone else on the call who also took computer programming in high school, those courses finally have a purpose. So when someone visits a website, there's a communication happening between their device and that website. Now, with session replay technology, it essentially takes the communication that's going on. So the tracking that's happening on the website about, hey, this person or this device clicked on this aspect, or scrolled through here, or visited these pages, or spent X amount of time looking at this portion of the website. It takes those interactions with the website and it sort of stitches them together and allows you to essentially replay the interaction that that person had with your website, hence the name session replay. It's very similar to other technologies that you have going on your website, uses similar tools because it all goes back to coding, right? When we're talking about cookies, we're talking about instances where you have two servers communicating to each other, and there's a piece of code that then gets attached to an individual user. And so when that user comes back, the server on the other side on the website recognizes them and can say, oh, hey, you were the same person we saw earlier on this website, and build that information, right? Website analytics, again, these are all just examples, right, of seeing what's going on the website and following those interactions. Key loggers look at, okay, what keys have been pressed? And so each of these loop together. You also hear references to pixels that we'll discuss further. Pixels are a lot like cookies, except it's technically different because you don't have servers speaking to each other. What a pixel is, and we'll get to further on, is where you're dealing with a piece of code attaching, but the way that works is it's a see-through image that's on the website. So you can see whether the person has seen that part of the website, but it's entirely see-through to the individual user, just a piece of code that you wouldn't otherwise see. And all of this pulls together into these technologies that we're going to be speaking about today. But for purposes of session replay, think of it as piecing that information together to see and replay how the person has interacted with your website.
And Trish, these are, it's fair to say that these technologies are ubiquitous, right? I mean, we, in counseling our clients on the compliance side, almost all of them are using some or all of these technologies. Would you
Yes.
call that a fair characterization?
Absolutely. And they serve a lot of different purposes, right? So if we're looking at session replay technology, companies may just want to see what's going wrong on their website, or which part of the website is attracting the most attention from people who then convert and become clients or customers of these companies, right? So session replay, you may be looking at, okay, well, people are clicking on this part of the website. What if I switch that button to blue instead of red, or I change the text? Am I getting more people clicking there? Are people spending more time on the page? All these website analytics are fueled by these questions that help the website to know, how can I improve? Or when you take it a step further, how can I address a need from this person? This person is clearly interested in a particular product. How can I look to them in the future and tell them about the offerings that we have, or remind them if we're dealing with ad tech that I know we'll speak about further, where it comes to, okay, I know they were interested in that product on our website. When they move on to another website, can I remind them about that offering? So it's both functional as well as learning what can we change, and then getting into the advertising piece of it as well.
I think it's helpful to have that context, because these technologies have this malevolent or sort of Orwellian connotation, I think, that is attendant to how they've been characterized in the litigation we're going to talk about and some of the enforcement proceedings. And it's important not to lose sight of the fact that these technologies are commonplace. They're critical to website operators and to modern day businesses. And they serve several salutary benefits or purposes, just as you've articulated.
Right, and I noticed a question. So when it comes to session replay, that is tracking an individual user's interactions. You can have data analytics that are on more of an aggregate level as well. A lot of this comes down to the settings that you have set up with the particular technologies that you're using.
So, Aaron, what are there've been a wave of litigation focused on session replay technologies in a variety of jurisdictions, and we've tried to summarize those here on this slide. But focusing on the session replay technologies, what are these claims that we're seeing, and what are the distinctions among them?
Sure. So I think we could start off with wiretapping. And wiretapping, Joe is a federal prosecutor, so we can really talk about this. And historically, what you think of as wiretapping is when the government would put a tap on somebody's telephone to monitor their communications. And there's a very long history of that. Every state has some version. In addition to the federal, wiretapping law, every state has some version of a law that basically prohibits intercepting telephone communications. And there's some variants. The big thing that you hear when you're talking about wiretapping is it a one-party consent state or is it a two-party consent state? Meaning that both parties have to consent, or can just one party, the party who wants to wiretap, who intercept a communication, be the one to give consent. So I sort of give that background, and that's this old-fashioned, and you'll hear this term a couple of times, this new wine in old bottles. Wiretapping laws have been on the books for decades. I mean, Alexander Graham Bell invented the telephone 150 years ago, and we've had wiretapping laws, for not quite 150 years, but a pretty long time. The way wiretapping laws have been attempted to be used, at least by private plaintiffs on session replay, is to take those wiretapping statutes and allege that the technology and the method that website operators are using, that Trish described, to contend that conduct violates a state wiretapping law. And really the three states in particular where this is a lot of the action have been California, Pennsylvania, and Florida. In Florida, there was a wave of wiretapping litigation involving session replay, sort of, I think it was the beginning of the pandemic, so 2020. The courts in Florida generally didn't let those claims go forward, and they, for the large part, have dissipated. There's still some that go on. California is a little bit of a wrinkle. Courts have gone a couple different directions, but the big issue in California and the statute in California is the SIPA. What is it, Trish? What does SIPA stand for? Consumer
Information Privacy Act.
Consumer Information Privacy Act. Thank you. Well, the big thing what the Ninth Circuit said under SIPA is for this type of, session replay or any really data you're doing on a website, you sort of need the customer's consent, which can be awfully cumbersome. And now it's a federal statute applying, federal court applying state law. So it's a question of how much that's binding, but that's in the water in California. There's some decisions that have gone a different way. Probably the biggest one in terms of a state privacy wiretapping law, going forward and causing a lot of problems for people operating websites, is in Pennsylvania what is called WESCA, the Wiretapping Electronic Securities Act, Communications Act. People just call it WESCA. I guess in Pennsylvania they have WAWA and WESCA. WAWA, good for coffee. WESCA, bad if you're wiretapping. Okay. What the Third Circuit said is, this customer went on a website for pet products. I think it was the stairs for a dog to go up and down. And the company was operating a website and said, you're doing this session replay. That's a big problem. Well, district court in Western District of Pennsylvania and Pittsburgh said, no, you don't have a claim there. And that was similar to a lot of other trial courts. Well, what happened? The Third Circuit Court of Appeals, one of the federal appellate courts, the appellate court that is the appellate court for Pennsylvania, reversed and said, no, there's a viable claim here. And since then, that was last August, in less than a year since that happened, there have been many very recognizable names. You can just Google them and see who they are. I won't mention them, but who have been sued in WESCA claims in Pennsylvania because of what the Third Circuit says. That's a big one. The problem is if you're operating a website, you can't say, well, my website can't be accessed in Harrisburg. Or, this website is good for everybody, but if you're up in Pennsylvania, sorry. No, it's a website. Everybody could access it. So you have to a lot of times you have to go to the lowest, the most risky state. So that's something to keep in mind. Other things in addition to the wiretapping laws, there's a whole bunch of other state privacy laws that folks have tried to make claims under. And, I can't go through them all. It's hard to even go through a lot of them, but every state has its own version of what's called the UDAP, the Uniform Consumer Statutes. People have tried to make claims under those. Sometimes there's question about whether there's damages, but those are in the water. Then you have your sort of common law type invasion of privacy claims that I always like to tell people at common law, it was not okay for your neighbor to step on your property, put 1 foot onto your property. At common law, that's what we called a trespass to chattel. And what that meant is you're entitled to, enjoy your own home and not be bothered. Now all of a sudden, does that mean I can go on my computer and type things and somebody could track that? Is that like your neighbor stepping on your yard? So I suspect that'll play out a little bit more in the years to come. We talked about the State Trade Practices Act. Larceny, that's stealing things, are they sort of stealing your information and conversion? And we already covered trespass to chattel. Some people call it trespass. I call it trespass because it sounds more old fashioned. But those are, some of the different types of claims that people are bringing on session replay.
And Aaron, it's I know we'll get to this with some of the other claims that focus on the digital advertising. Quite often, the impetus is going to be: does the claim, or particularly the statutory claim, provide attorney's fees, right, or statutory damages, all of which can be attractive to a plaintiff.
Right, and the big thing, Joe, of course. So we have statutory damages, but if I'm Joe Schmo and I'm bothered that a website operator was using session replay, and I file a claim, for $1,000 under some statute, well, it's a pain in the neck, and the company operating the website is going to have to, go to court and defend that. But okay, that's not that big of a deal. They're seeking $1,000. The big thing is these are often filed as class actions. At the majority of cases on these session replay claims are class actions, and that's obviously a whole different, that, as they say, that's a horse of a different color.
And Trish, we got a question before today that I think is worth touching on here on this slide, and that question was, are these actions, the ones that Aaron's just been talking about, is there a chance that they would be preempted, were the federal government to enact some kind of sweeping privacy legislation? Any thoughts on that, Trish?
Yeah, I think it depends which claim you're talking about here, right? If you're talking about ones based in a state privacy law, then there's probably a better chance of that. But I think it's highly unlikely to address all of these different theories, particularly when you look at, so for example, wiretapping, right? Because there's already a lot of variation from state to state in wiretapping laws. There's already federal and state law on that, and they haven't taken the step to preempt in that sphere. So I think it's highly unlikely that on the federal level, we're going to see a privacy law that will sort of address all of these various claims that could be raised here.
Right. And as you said, Trish, in the last Congress, they got pretty far, and then there was some opposition from powerful interests. I haven't really seen much that it's even, I know we're only 3 months into the new Congress, but I haven't like seen it identified as a particular priority. And then, we're in, once we get to 24, we're already in a presidential year and it's hard for anything to get done. So could be a couple of years. I mean, who knows, predicting what Congress does, you're not going to get very far, but there seemed to be more in the air of an impetus for a federal privacy law in the last Congress.
I don't know. Then again, we have these more and more states coming on board with their laws, right? We've already had Iowa, now Indiana is supposed to be within, a couple days. So it's sort of like, what will be the straw that breaks the camel's back, right?
Exactly.
So we'll see.
Aaron, you touched a bit about and kind of foreshadowed some of these defenses and the viability of these claims when it comes to session replay technologies and the fact that they've persisted in Pennsylvania, not so much in Florida. What at a high level, what are some of the substantive defenses that are raised in these cases? What's been successful, and what are some of the class issues that come into play?
Sure. Well, one substantive defense in particular has to do, particularly in federal court, but some states as well. Have you really suffered an injury? So if somebody has invaded your privacy, is that an injury that could be reduced to an economic amount or a quantifiable amount, or what it really is the injury? So that's something that folks have done. Private causes of action, there's always debates over whether these statutes have a private cause of action. And then things like the Wiretapping Act, the term I used and said I'll come back to is the new wine in old bottles. Are you really sticking vinegar into an old bottle, or is it really wine into the bottle? In other words, does it fit? So in Florida, basically the courts have said no, it doesn't fit. So that's something there on those statutory type claims. Statutory type claims can get kind of tricky. Whether as new tech comes, a lot of these statutes that courts are grappling with, and we'll get to another one when we talk about the digital advertising. But a lot of these statutes were written a long time ago, 70s, 80s, and the like, and now we have new tech. The World Wide Web wasn't invented until 1990. So a lot of this stuff, is really trying to figure out what fits. Does the old fit? Does the new fit into the old? And I mentioned these cases get filed more often than not, probably most often as class actions. So what defenses do you have on class action? Well, it's very specific. What's the conduct? If I'm logging on, what were my expectations? Are those the same that Joe and Trish had? So whenever you're defending any type of class action, but these two, it's always, was the experience of the individual person, can the website operator argue that it was different in a material way such that a class action shouldn't stand?
And because, Aaron, at least in the federal system where you've got Federal Rule of Civil Procedure 23, a big argument is going to be that individual issues among the class predominate over class-wide.
Yeah, and that's generally going to be the case for, Florida. We have Rule 1.220, which is very similar. I mean, basically every state who has a class action mechanism, some of them don't, like Mississippi can't do these class actions, even New York, not that easy in consumer class action. But most states do allow for class actions, but they're going to have as Joe said, the mechanisms for individualized inquiries. And then another thing is, always have an interesting question here. Do people who use the website, are they actually customers that have agreed to terms of service? So you're dealing with sort of your active, customers who have terms of service versus people who may just be browsing on your website and may not have terms of service. They may have never done business with you. So that's a big difference, and that's a significant difference in class.
Okay, so now we move on to digital advertising tools. Trish, you previewed some of these when you were talking a few minutes ago about the various website technologies. But let's take a little more time here and drill down on, what do we mean by digital advertising tools, particularly the ones that have really spawned this wave of litigation over the last year or so.
Right. And so here remember that it all comes back to coding, right? What's coded. So when this person visits the software, there's a little bit of code placed on their device so the websites can recognize them, right? But that can track you across websites. So particularly for digital advertising, it's used to say, hey, this person visited my website. Maybe they watched this particular video about a product, and I want to remind them of that when they move on from the website. So they'll move to the next website, and there's this marketplace that happens, right, with information about this individual so that the people who can want to use their ad dollars most effectively, right, can reach out to this person and show them ads that are relevant to them. And that's basically what you're seeing. Basically, the little piece of code translates into a marketplace to use advertising dollars more effectively as this person moves around to different websites. One of which that has attracted particular focus is Meta's Pixel. And again, as I mentioned with a pixel, it's not something you can visually see when you're interacting with a website, but it is a transparent, so invisible square that is on the website that lets you know when someone has seen what is there. That information then, this one specifically would go to Facebook, who would then pull up on Facebook's website when you visit ads related to what you've seen elsewhere, what you viewed elsewhere.
So one use case might be, private business has a website and a visitor is on that website. They also have a Facebook account. The Meta Pixel, notes that user was on that website. And when that person is then using Facebook, they may receive ads from that business whose website they were previously on, with the aim to convert them and complete whatever transaction may have been considered while they were on that website. I would just add too, again, there's this sense, if all you did was read these complaints that we'll talk about, you get the sense that this is all malevolent and in the shadows, and nothing could be further from the truth. I mean, Meta advertises their pixel, and it's quite easy to read about and know what it is. I mean, would you agree with that, Trish?
Yeah, absolutely. I think the regulators, I was just at the IAPP conference last week, right? And the commissioner from the FTC called it a back alley exchange. That is their view of digital advertising, right? And at the NAIC Privacy Working Group, they are working on revising basically the privacy law as it applies to all insurers. And a large focus of these consumer advocates is what's going on that they don't visually see, or that they just don't understand, maybe. There's a lot of disagreement about that, but broadening the view of obligations and what's private. And that is a theme that then, of course, comes up often in the litigation as well, right? So for thinking about this, I think when you're trying to reduce risk, transparency is the name of the game.
Trish, you talked about Meta and its Pixel. Google has tools here as well, right? Google Analytics.
Absolutely.
What have you seen there with Google Analytics and its uses?
Sure. I mean, just about everyone uses Google Analytics, right? And then on the Google Analytics piece of it, again, they're recording interactions with the website. And a lot of that can just be, hey, we want our website to work well. Like if it's crashing, we want to know. Or we're trying to see where's the fall off in users to our website, or who actually becomes our customers, and using that and communicating that. That's very helpful to a company, not just for advertising, which is of course a piece of it when we work with things like Google Ads and wanting to actually know that a consumer has a need that I can address, but also in just making things work, right? Nobody wants the website crashing and not knowing about it. If it's hard to read and I can improve the interactions on my website by changing the text size, then that's helpful to know. And that's helpful, right, to a consumer. But that doesn't stop regulators and consumer advocates from often portraying it as some nefarious task of, you know, monetizing and exchanging information. So it, you know, it comes down to spin, really.
And this was another question that we got before today's event, and it was, you know, one of the participants in the audience expressed some, you know, an observation that at least with regard to Google, and we have heard this with Facebook as well, it is difficult to know in the configuration process what exactly you, the company, are enabling when you set up the Pixel or you set up Google Analytics, and you may be checking X number of boxes and thinking that you are only soliciting a finite set of data, and it may turn out that the data being collected, shared, what have you, exceeds that. Is that something that you've seen, and you know, what might be the practical impacts from that?
Yeah, it's a problem that everyone's facing, right? Because it's not that easy to get information out of these large providers about, you know, all of the information that they're collecting, though their terms will place the obligation to receive those consents on the company who has the website, right? So I think you deal with it in a few different ways. One, you don't want to be the low-hanging fruit. And so you build a record of all the efforts you've made to try to learn about it, right? We reached out to Google, we submitted a question, we didn't get any response. We've set our settings in a conservative way. So for example, this goes back to session replay, but with session replay, there's typically a blur setting you can turn on so that you're not seeing what people enter in the text box itself. So you want to make sure the same kind of thing with Google. You can limit some of the sharing just in the settings that you set up. Second, we want to increase that transparency, right? So within your privacy policy, just saying, and we use Google Analytics, and here's some information that Google has about that, right? And referring the person back to Google, because maybe that's the best you can do if you can't get the information from Google.
Yeah, and I would add that in our experience, talking to clients about what technologies they are using, to your point, Trish, it really is, it's more often than not the case that the client is not fully aware of all of the technologies and may even need to use a third-party auditing firm to help, you know, evaluate the website and compile an inventory of all of the technologies being used and the data elements being captured, because of the difficulty and the lack of transparency between the website operator and Facebook and with Google. And so I think, you know, your observations on how to reduce the risk are right on. And I know Aaron will get to this too when we start to get into the claims. You know, some of these claims are going to turn on whether you, the defendant, the website operator, knowingly conveyed information to Google, to Facebook, to some third party. It may be a defense in that litigation, though everyone would love to avoid the litigation in the first place, that, hey, you don't have a claim because there was no knowing transmission of this information. We set up this service in such a way, turns out it was getting more than we thought. That makes your claim not viable.
Right.
So speaking of claims, Aaron, there's a host of claims that we see asserted here, attendant to the use of Google Analytics, the Metapixel. Again, we've listed sort of a laundry list here of ones we've seen in cases we are defending and others that we are following. What stands out to you in this list of claims, Aaron?
Sure, and we talked about, you know, obviously some of these in the session replay stuff, so I won't really go over those. But some that are unique to the digital advertising. Probably the one that to me sticks out the most is the Video Protection Privacy Act. And this is really, to go back to my term, the new wine in old bottles. This is a statute that dates back to the 1980s. And for anybody who was around then, this had to do with when Judge Bork, who was a judge of the DC Circuit, was up for consideration for the Supreme Court. the seat that became Justice Kennedy's seat, incidentally. And Judge Bork, you all could Google it. He had a controversial or record on certain things that were hot button issues. So an enterprising reporter for one of the local papers in Washington, D.C. went to Judge Bork's local video store. So remember, this is 1987 when you used to have videotapes. And the reporter asked the video store clerk, well, could I see, what movies Robert Bork rented? And the video store clerk, I don't know, didn't think anything of it and gave the reporter a list of, over 100 movies that the judge had rented. And it was, nothing out of the ordinary. It was probably, the last couple of years, top 20 movie releases and some classics, and publish it in the paper. Well, Congress got all out of sorts over this and prompted Congress to pass the Video Protection Privacy Act. And what that did is it basically said that somebody who's in the business of renting and providing video cassette tapes cannot give your rental history. Now, as I said on the other part, the World Wide Web wasn't even invented until 1990. So there, we had videotapes, but no World Wide Web. Well, 35 years later, and with this pixel type software and similar type technology, the argument is that that's just like somebody having access if you're viewing videos on a website and that website operator's information is being sent to a third party like Facebook or Google or similar type company. The argument is that is tantamount to the video store clerk giving the reporter Judge Bork's video rental history. And those claims have really skyrocketed. There have been quite a few of them against real brand name companies. You would recognize the names right away. In the last year, some courts have let these claims get past at least what's called the pleading stage, meaning you get past a motion to dismiss. One court, at least in the Southern District of New York, cited for the defendant on that case as a magazine publisher. So we'll see what happens, but that's going to shake out. But there's that's where we've seen quite a lot of action, and there's other statutory claims. The computer fraud and abuse, that has to questions. Does the website operator? The question is, did they exceed the authorized access? If somebody goes on your website, are you essentially agreeing to them taking your information? So we'll see what happens with all these over the next couple of years, but there's no shortage of creativity amongst folks who want to defend defend the rights of people who feel that they had their privacy violated by these Google Pixels. So watch that space.
And I would add too on the VPPA claims, there's, what I think has made them attractive. And, to Aaron's point, there've been 60 or 70 of these class actions filed in the last 9 to 12 months. And they've only been filed with increasing frequency after a number of them got past the motion to dismiss. They provide $2,500 per consumer in statutory damages. So, on a class-wide basis, that can be pretty significant if you think of all of the potential visitors to a company's website. I would add there too that at least initially, the targets of that litigation were mostly, if not exclusively, media companies, companies that have and as part of their business tend to put up a number of videos on their websites. That is no longer the case, though. Over the last several months, we have seen life insurance companies, financial services companies sued, others in a variety of industries, because again, it's pretty commonplace these days for website operators, regardless of the industry, to have a video, a vignette from a customer, a vignette from an employee talking about a product. And, if that company is recognizable, or there may be a large class, I think that's going to make that company an attractive target. And because these cases are surviving motions to dismiss, perhaps in part because the courts just don't know what to do about them because they're so new, it means these cases are getting into discovery, and that's where the real costs can accrue and make really increase the pain on defendants, which becomes an attractive leverage play for the plaintiffs looking to push these along. I mean, Aaron, anything to add on that based on your experience with class actions and just the sort of cost benefit analysis that goes into defending them?
Yeah, put an arbitration clause. I mean, as they say, it's not hard, people. These are subscribers. If you don't want to be sued in a class action, you put an arbitration clause on your consumer terms, but some people don't do it.
So have that in your website terms of use, and then keep records of who's looked at and accepted those terms.
It's not so much your website terms of use, but it's at least for your to the extent that at least VPAA claims are talking about subscribers. That's somebody who, if they're the person who has the claim, that's somebody who you are going to have a pre-existing relationship with. So you're presumably going to have agreed to some type of terms with them. And if you want to protect against a class action, I'm not the first person that said that, but I'll say it pretty loud, put an arbitration clause. But, some people, for whatever reason, don't want to do that.
Understood. Final observation I would make about the Computer Fraud and Abuse Act, that's a criminal statute. It also has a civil component, but it was something we used as prosecutors, and I think is most commonly thought of in that realm. It does have a civil component, and it's making its way into these pixel class actions under the theory that the plaintiff's phones and webs and computers are protected devices, and the use of the pixel or the use of Google Analytics exceeds the authorization for the website operator or Facebook that they may have. And so, again, stay tuned for whether any of these claims get any traction. But it's another illustration of old statute, old cause of action, relatively speaking, being applied to a 21st century fact pattern. Trish, I want to pivot back to you to talk a moment about the regulatory enforcement. We've been talking largely about private litigation. The regulators have been very active in this space, which has then created kind of a feedback loop with the plaintiffs who are emboldened by the actions that the regulators take, and so on and so forth. What do you mean here, or what do we mean by this right to opt out of targeted advertising, and what that means from a regulatory enforcement perspective?
Sure. So there's been a few focuses from regulators here, right? One thing is the right to opt out of targeted advertising, and this has stemmed very specifically, I'd say, in recent comprehensive state privacy laws. Right, where they're actually saying, look, if you're going to be doing this kind of targeted advertising based upon someone's activity across websites, that at least if they're one of our consumers in these states that have these laws, that we are going to require you to provide them with this opt-out. So particularly in California, that's what triggered when you started seeing these, right to opt out of the sale or sharing of my data links on websites. Another piece that they focus on is viewing digital advertising as a form of impermissible disclosure. So this has been a huge shift for healthcare companies, especially stemming the December 1st, 2022 OCR bulletin, which said basically, if someone is on your website and they are looking, for a doctor to help them with a particular medical condition they may have, when you share that information with a digital advertiser, they are viewing that as a disclosure under HIPAA, and it's a disclosure of medical information. In the past, the broad view across the industry was that was not medical information, that was not protected health information. But OCR has now come out saying, no, we think it can be, because you're revealing the fact to this digital advertiser that this person has, maybe sought to contact a particular doctor or has been seeking help for this particular medical condition. So that's been a large shift, and it's one that the FTC has followed up on, right, and agreed with. So there have been, I noted 2 settlements here. The first that came out was a settlement for 1.5 million with GoodRx Holdings. And what happened there, this was the first time that the FTC came out with a settlement related to their health breach notification rule. And what they said is that this is an impermissible disclosure of health information. And, 1.5 million from that, right? And it was based upon the use of ad tech. Then you had them follow up with a $7.8 million settlement with BetterHelp. Again, the theory is that you're sharing consumers' personal information with these third-party advertising platforms. You didn't receive an authorization to permit this disclosure. So that's been a breach in that sense, right? And that you have representations in your privacy policy, say, about being HIPAA compliant or the confidentiality of people's information. But if you're sharing it with advertising providers, then we're going to say that your privacy policy is deceptive.
So you're right. It really heralds this focus on the regulatory side for disclosures and the importance of transparency as best as can be achieved. And that that OCR bulletin that you noted really was a sea change, don't you think, Trish, in terms of it characterizing things like an IP address as protected health information according to that bulletin. And if that's the case, then almost anything on a website for a covered entity under HIPAA, talking about healthcare, could be protected health information.
Yeah, and this is a much bigger trend, right? It's beyond healthcare. And I think this has been one of the themes that comes up over and over when we are helping clients and getting those communications happening between the marketing department and the legal department. Because so often someone in marketing will say, no, we don't have any PII, but we're not dealing with PII anymore. We're dealing with personal information, right? So they'll say there's nothing. And then so you'll ask, well, are IP addresses being used? And the response will be, well, yeah, of course. And it's like, well, that's personal information. Right. So there's been the privacy law developing here. And again, it's not just in healthcare. So for example, within life insurance, we do a lot of work with these clients, and the seas are changing is what I will say on this, right? Currently, we do this analysis, often dealing, well, where does Graham-Leach get triggered so we can have the Graham-Leach exemption? And well, we don't think that just a website visitor is going to fall within that, right? Well, that starts changing when you have things like what the NAIC is doing now with its privacy protections working group. And we're on every one of those calls. And it's, I think, shocking to hear the changes that they are planning, right? Because now it's not just about what we would think of as like, well, that's sensitive information, right? It's about, well, they were on the website and you don't have a right to know that I was on your website or share that with an ad tech provider. And the regulators are seemingly agreeing with this, right? And expanding the restrictions on gathering that information and using it for marketing purposes. I mean, they're talking about switching everything, right? They are discussing using an opt-in for any kind of use to reach out to this person about the product, even when they're visiting your website. So there's substantial change happening and a focus from regulators as far as what data are you collecting. So I think a huge piece here is getting your hands around what data you are collecting, right? What is your website doing? And that requires, I think, sensitivity building with the marketing department and really diving into what are you doing? How are you doing it? Because it's well-intentioned, right? The marketing department's out there trying to grow the business, and they're using tools that seemingly everybody they know is also using. Right? But that doesn't mean there aren't legal implications. And that doesn't mean that we can't address those tools and try to make a particular company not the low-hanging fruit, right? And so that's a large piece, I think, that you can do on the front end that doesn't say no marketing, you can't do that. It says, okay, you want to do that. How can I get you there while reducing the risk?
We used to say on the cybersecurity side, the best thing to do from a prevention standpoint would be to ensure that the general counsel has lunch with the chief information security officer so that the right hand knows what the left hand is doing. I think that recommendation could be repurposed today to say in-house legal, general counsel, whomever needs to be talking to the chief marketing officer and the head of digital ad strategy so that the right hand knows what the left hand is doing.
Right.
Because where there are disconnects, we've got these claims, and it remains to be seen whether they will be successful. Aaron, what are some of the defenses we've seen or we have even asserted on behalf of clients, some of which we've sampled here?
Yeah, I mean, as you said, some of the things like HIPAA, awfully hard to bring a private cause of action under HIPAA. I mean, sometimes people try to shoehorn HIPAA into a state UDAP claim, kind of hard, but go for it if you think it can work, but pretty good defenses. As you said, statutory things like under the VPAA. Well, we're not a videotape service provider. We're not Blockbuster or your local video store. We're some just a plain old website. That it actually wasn't intercepting. And that's if it's a direct one-to-one, is it intercepting? Contract, is there a privacy notice? How good are the disclosures? And then consent. I mean, there are a lot of things, as I talked about the arbitration clause, but there are an awful lot of things. It's not perfect, right? There are some things like VPA may say, well, you got a separate disclosure, but there's an awful lot of things that you can do to defend yourself with having a good privacy policy with good disclosures and good consent. It said it's not perfect, and there are some things that you're going to need a very specific form in a e-signature or something like that, but you're still better off if you at least have some type of form of consent than somebody who doesn't have that.
And that's often where you see like pop-ups and checkboxes being used as well. I know we had a question here about in the digital space, how do you obtain consent online, right? And it depends on how much consent you need, right? There's notices, there's acknowledgements, there's authorizations, there's checkboxes, and what you record on the back end. So some people record the fact that like, can we make the person scroll through the authorization before they check the box to affix a signature to it and that kind of thing. But it really depends on whether you can combine them, right? Everyone always wants to have as few checkboxes as possible, but there's some of those in like higher risk areas where we say, no, you can't combine, right? With TCPA, right? If you want to be sending a text to someone's phone, you're not going to group that consent in with something else and try to argue that that will stand typically, right? Because you want to be safer. Or with HIPAA authorizations, right? There's these authorizations that you can't just be grouping in typically with other consents.
Yeah, it's very hard. It's, it's people want to operate websites and do business that way. And then you have lawyers screaming in their ears, well, you need this pop-up and you need 19 different consents. I'm just making up that number for the person who just wants to look at our website and see what flowers we're selling. I mean, it's hard.
And I think, we're going to see a move to, over the last couple of years, we've all gotten accustomed to seeing these cookie banners at the bottom of websites, driven largely by positions that regulators in Europe were taking about cookies and the nature of consent that needed to be obtained. I think, particularly for those companies that in the United States, want to take a particularly conservative approach, they may take the view that, yes, even for someone coming to check out the flowers on our website, we need some sort of documented affirmative consent because we're otherwise faced with the specter of this litigation. That may make for a cumbersome user experience, but it's again something that legal and the marketing team need to be working on hand in glove as best they can.
Yeah.
So go ahead, Trish.
I was going to say, I think there's always there's trade-offs, right? But there's also studies showing that the more transparency that you have, the greater trust there is, and that's part of your brand that is being sold, and that increases sales. So I think there's often this view that privacy puts a stop to things, and I don't think that's true at all, right? Privacy can be a business differentiator. Privacy can improve your business. You have to do it carefully, and it doesn't mean it's all about privacy and sacrifices other things. These things can go together. right? I don't know of really any business who takes the approach that we're going to put our website behind a consent banner where you have to check that you agree to our privacy policy before you can even visit it. Sure, that would be safe, but it can also, we think about, well, when we know the technologies, and this goes to these risk reducing measures, right? Understanding what we have in place, okay, how soon do we need to put in something, right? We're obviously going to have the privacy policy posted on our website, but can we get an acknowledgement to it early on? At what point, right? Can we blur settings and working our ways through the timing and how we record consent?
And
so
one
I
of the
see-
questions, one of the questions we had before today's event was what kinds of disclosures should be considered as it pertains to the use of chatbots or virtual assistants, which have also become commonplace on websites, particularly with the advances in AI. Trish, if I hear you correctly, then maybe the answer to that is all things for lawyers, it depends. But if your website is not triggering the chatbot or the virtual assistants until the user takes some additional steps, maybe that's the point at which you provide that consent so that you're not making that a gating function before anyone could even visit the website, even if they have no intention of engaging with a virtual assistant or a chatbot. Anything you'd add to that?
Yeah, I think it also depends, obviously, what's the chatbot doing? What kind of data is it working with? Is it using AI to make some determinations that have like a legally significant impact on the individual, right? Because then we start dealing with all these more involved AI concerns that I think could probably support their own webinar going on for an hour about them. But I certainly think notice at collection there, right? Making sure that the privacy policy is being linked within that interaction so that people understand when they're submitting information to this chatbot, what's going on with that information, what's being gathered. And as you said, if they've acknowledged that information they're going to give to a chatbot will be used in conformance with this policy already, that's obviously much lower risk than what sometimes happens if you don't think about the timing, is that people start providing information, but they haven't agreed yet to the privacy policy. And we saw litigation against a life insurer last year that focused on the use of this quoting tool, right? And that looked at that and said, well, I didn't accept until later on in the process that I accepted your privacy policy that talked about session recording, right? So all that information that you saw about me in this session replay technology beforehand, I didn't give you permission for. And so by moving up the consents and really focusing on, okay, let's give you a fulsome disclosure. Once we understand our technologies, let's disclose them and be transparent with them and provide you that information. Let's get your acceptance of that as early on in the process as we can. And that is a huge step in reducing risk, right? And documenting how you've shown acceptance of that. One other thing I'd add, and that we've been doing recently, is bolstering up those cookie banners, as you mentioned, Joe, right? Cookie banners can deal with cookies, but what we've done is suggested like, hey, why don't we add a note about those early on analytics going on our website? That way, like, all right, you don't want to block the whole website with an acceptance. We don't feel comfortable moving that further up, but okay, at least we have something that pops up that tells the user like, hey, this website uses certain technologies such as session replay and cookies, right? And then you have the rest of the usual cookie banner info and you have the link to your privacy policy, but you flagged for them, hey, something's going on here. So, you try to balance things and move forward as you can, but a large part of it is getting your hands around what's going on, speaking to people internally, using privacy settings where you can, getting great disclosures in place and recording the acceptance, as well as those sort of contractual provisions that Aaron was mentioning.
We are at the top of the hour and we're at the close of our presentation. In the 30 seconds or so we have remaining, I note that we've gotten a couple of questions about how the pixel functions. Would be happy to take those questions offline, just given that it is the top of the hour. There are fairly helpful disclosures, I would say, on Facebook's website about how the pixel functions But we would be happy to talk about that offline. Trish, you commented about obtaining and proving consent. And there was a question that I think we can answer in the same way, and that was, do we have any recommendations for third-party firms that might audit website technologies? This is a burgeoning field that has been flooded by a lot of players. And so, my answer to that would be talk to your auditing firm. I think quite often the auditing firms are going to be providing solutions in this space. And all the big consulting firms are developing practices in this. Trish, we were just contacted yesterday by a top tier firm that was announcing the creation of a practice that does just this, website technology auditing. I think those folks are also going to be the kinds of people that you should talk to about how best to memorialize the consent, which is, again, more of an operational technological question that I think those folks would be best equipped to answer. And I think that was it for our prepared remarks. Anything else that anybody has for us questions wise, we're happy to take them now. If not, this session has been recorded. The PowerPoint will be circulated along with it. And that includes our contact information on the final slide. So without further ado, and on behalf of Trish and Aaron, I'd just like to thank everyone for your participation today. Thanks to Trish and Aaron for their very helpful remarks and their experience. And we hope everyone has a good rest of the day.